Hello, happy to spend a little bit of time with you. Today I would like to talk to you about broker supervision. I decided on this topic because of something I recently heard a broker say. Without revealing too much information, a Utah broker, when questioned about providing adequate supervision over their agents, said something like, "It is not possible for me to supervise this many agents." A little bit more on this later, but I wanted to go over a rule amendment that was passed in June of 2021 dealing with broker supervision. Hopefully you are all familiar with this rule amendment. This rule specifically states that a broker is required to provide active and reasonable supervision over each licensee and unlicensed staff member employed by or affiliated with the broker. The rules now define what active and reasonable supervision includes. Brokers must have written policies, rules, procedures, and systems that allow the broker to review, oversee, inspect, and manage several things, including real estate transactions performed by a licensee either at the main office or a branch supervised by the broker, documents that may have a material effect upon the rights or obligations of a party to such a real estate transaction, the filing, storage, and maintenance of such documents, the handling of trust funds, advertising of any service for which a real estate license is required, familiarizing licensees with the requirements of federal and state law governing real estate transactions, including prohibitions against discrimination. Ensure that each affiliated licensee is able to maintain reasonable and timely communication with the supervising broker or a competent designee to assist the licensee with real estate transactions handled by the brokerage, and maintain adequate, reasonable, and regular contact with each affiliated licensee engaged in real estate transactions so as to prevent or curtail practices by a licensee that would violate the provisions of this chapter. The rule amendment also requires brokers to be reasonably available to the public in order to discuss or resolve complaints and disputes that may arise. Provide guidance to and instruction and oversight of each licensee and unlicensed staff member regarding the policies, rules, procedures, and systems of the brokerage. Documenting the instruction and oversight provided. Establishing a system for monitoring compliance with the policies, rules, and procedures and systems of the brokerage by licensees and unlicensed staff members. The rules allow a broker to delegate any of the items I have mentioned to a licensee or unlicensed staff member, except that a broker may not relinquish overall responsibility for active and reasonable supervision of the acts of licensees and unlicensed staff members affiliated or associated with the broker. In establishing policies, rules, procedures, and systems, the broker shall consider the number of sales agents and associate brokers and the number of locations of branch offices supervised by the broker. This takes me back to the story I shared with you at the beginning of my presentation. When establishing your brokerage or the structure of your brokerage, keep in mind how many agents you have and if you can provide reasonable and active supervision. If you had the same thought or have said a similar thing to the broker I talked about, then you should rethink how you structure your brokerage. Now, in addition, there is a safe harbor for brokers. There is a way for brokers to protect themselves from liability. The rules state that a principal and branch brokers are responsible for violations of their licensed and unlicensed staff they supervise, except that neither a principal nor branch broker shall be deemed in violation of failing to exercise active and reasonable supervision where the supervising broker had in place at the time of the violation specific written policies or instructions to prevent such a violation, reasonable procedures were established by the broker to ensure that licensees receive active and reasonable supervision, and the broker has followed these procedures. Upon learning of the violation, the broker attempted to prevent or mitigate the damage. The broker did not participate in the violation. The broker did not ratify the violation. The broker did not attempt to avoid learning of the violation. If you follow these steps, you will be protected as a broker. Please take the necessary steps to protect yourself. Thank you for all you do for the state of Utah, for your industry, and the citizens of Utah.
Hi, I'm Kreg Wagner. I'm General Counsel for the Utah Association of Realtors. It's a privilege to be able to talk to you today a little bit about some of the things that I see on the UAR hotline. One of the questions I get that is pretty consistent over my almost 11 years at the UAR deals with seller's disclosures. Yeah, I know that's everyone's favorite topic. We want to talk about seller's disclosures, but let me just kind of highlight a couple of things that I see on the hotline. So when does a seller have an obligation to disclose all known material information about the property? Well, under the Rep C, it's under Section 7. There's a specific deadline for the seller to give disclosures about the property. Now, you'll notice under the Rep C, Section 7, there are a number of items contractually that a seller owes to the buyer by that set deadline. Oftentimes we think, it's the UAR seller disclosure form that helps comply with Section 7A. It's in writing. It's signed by the seller. That's good enough. I guess a word of caution is just to make sure that your sellers understand all of their contractual obligations under that deadline. So, for example, some of the issues that I see would be a commitment for title insurance or the HOA minutes. If those things are provided by the seller after the seller disclosure deadline, really there could be an argument that the buyer has seen a breach of contract from the seller. When you look at Section 21 and you look at Section 24, those are things that really tie Section 7, which is the seller's disclosure section, together. So really, as a point of emphasis for listing agents, make sure that the seller's disclosures are completed. Make sure that the items enumerated in Section 7 are completed. And that's going to be key to protecting your seller and protecting their interest. It's certainly in the interest of the buyer to make sure that they receive all of the disclosures required so that they can then conduct a thorough due diligence under Section 8 of the purchase contract. Another thing that I want to emphasize under the seller's disclosures would be, what does a seller have to disclose as far as materiality? What important things does a seller need to disclose? Well, the Utah Supreme Court has said really a seller's obligation by virtue of the buyer-seller relationship has an obligation to disclose all known material information. And materiality is defined as important information that would affect an ordinary prudent buyer in assenting to a particular purchase price. So it's a pretty broad definition. And so from my standpoint, and other attorneys that I've talked to, you're going to want to disclose as much as possible to avoid any sort of confusion. In essence, you're shifting the burden onto a buyer to do their own due diligence. And then that way the buyer is buying the property as is. Many of you have heard of the doctrine of caveat emptor, let the buyer beware. That way they're doing it with all eyes wide open. They know what they need to check into the property. They've had full disclosures by the seller. And then that way they can conduct a thorough due diligence of the property. Another question that I've had, or a point of emphasis, would be, well, the seller has given disclosures and I still have some questions about what the seller's disclosed. Certainly a buyer is free to ask questions, to negotiate additional terms of the contract based on the seller's disclosures. If you look closely at Section 7A, which oftentimes the UAR form is used to comply with Section 7A, it simply says that a seller is to provide a written seller property condition disclosure that is signed and dated by the seller. So technically, there's not an obligation for the buyer to sign seller's disclosures. With the UAR form, the buyer does have a signature line that is simply to acknowledge that the buyer has received the seller's disclosures. So if your buyer receives seller's disclosures and they're being asked to sign them, certainly they're going to want to consult with their own attorney as to the legal effects when it comes to a buyer signing a seller's disclosures. Just something that we've seen kind of come up and just wanted to make you aware as you advise your agents and as you advise your clients when it comes to a buyer's responsibilities. Lastly, I would just advocate that, look, we're trying to avoid litigation. We don't want a buyer suing the seller after the fact. That's really not good for anyone other than the attorneys involved. So I guess what I would say is just advocate full disclosure by the seller. Make sure they're fulfilling their contractual obligations. Buyers, make sure that you're doing a thorough due diligence. Make sure that you understand what exactly you're buying. I would be very hesitant if I were a buyer or representing a buyer in waiving due diligence or waiving inspection, because I want to discover what I'm buying. I want to know what I'm buying to avoid any sort of potential litigation after the fact, especially if the transaction's been seamless and it's been something that's been positive for all parties involved. If there's ever any questions, I want to be a resource to you as brokers. I want to be a resource to your agents. So if you ever have any questions, feel free to call the UAR Legal Hotline, and I'm happy to answer those questions. We're open Monday, Wednesday, and Friday from 8:30 to 4. Certainly, you can leave a message anytime, 24/7, and we typically get back to you on those days. Thanks, and have a great day.
All right. For all of you that are in attendance today, my name is Brad Bjelke. I am the CEO of UtahRealEstate.com. We are the MLS for the state of Utah, but we also cover areas in southern Idaho, western Colorado, a little bit of Nevada, and northern Arizona. So I'm excited to talk to you today about copyright law. And it may not sound like the most exciting topic, but copyright law is a huge part of the multiple listing service world. It is a legal topic that is brought up annually in our industry. And the reason for that is copyrights are essential to the listing process. And many people don't think about copyrights when they do listing input, when they take photos, but copyrights are essential to the listing process. The definition of a copyright is really a type of intellectual property that protects the original works of authorship as soon as the author fixes the work in a tangible form of expression. And that's a very legalese sort of definition that you'll hear about in a textbook or on stage from an attorney. But really what it means is the minute you create something, the minute you have the spark of creativity is what many refer to it as, you now own a copyright. You have a copyright in your name. Typical copyrights are things like paintings, novels, photos, sound recordings such as this, music. Pretty much anything that is creative and that is created by the author can be submitted to copyright protection from the United States government and the Copyright Office. But the key to the Copyright Office is that it has to be independently created by a human author. And that is the wording that is used. And one of the topics I want to touch on today is lately there's been so much talk around artificial intelligence. And it's an interesting topic. It's obviously hitting all kinds of different industries, but in real estate, it hasn't really come to fruition yet. However, artificial intelligence will be in our market very soon, from everything from writing the description of a property to potentially creating works of art around a property. Now, how long does a copyright last? So a copyright technically lasts 95 years from publication, or 120 years from the creation of the copyright, and whichever is shorter. So publication, obviously, you publish a novel, you make it available to the public. Maybe you record a piece of music in a studio and you never publicize it. That would be the 120-year limitation. So copyrights last a long time, and they can generate a lot of money for authors of the works of art. MLS copyrights. So what inside the MLS is copyrightable? And a lot of people will say, well, what about the number of bedrooms, the number of bathrooms, how many garage car ports or parking spaces that there are? Those are not copyrightable, right? So facts are not copyrightable. So anything you get from the assessor's webpage, any facts that come from information about the property that you put into the listing, those are not going to be copyrightable. There's no creativity involved in making that information available. However, there are some things in the listing that are copyrightable. First and foremost are the photos, and we're going to talk about those in a minute. The other thing that is very apparent is the agent remarks. Agent remarks are really the spark of creativity for agents. And that's where you're going to say, hey, this property is a beautiful 3-bedroom, 2-bath home located in this wonderful neighborhood, et cetera, et cetera. Those remarks are your creativity. They are original works of authorship. Photos are the difficult part of things, because if you go to a property and you used your own camera or your phone to take photos, you are the author of those photos. Therefore, you hold the copyright. However, many brokerages utilize professional photographers to take the photos for the agents. In that situation, there could be a blurring of the line of who owns the copyright. And if you're taking the photo, you are the author. However, if you're basically paying for a work for hire, or it's an employee of yours, if your contract and your employment terms are clear, then that copyright will be transferred to you as the owner. However, if it's not clear that it's a work for hire, the ownership of that copyright is going to remain with the person who took the photo. And so what I recommend is really that we, as agents and brokers in the community, ensure that the photography companies that we use, the photographers that we hire, or even the people that we utilize to take the photos clearly have a contract in place that it is a work for hire. It is being paid for by the agent or the broker to create the copyright for the property. Without that clear language and without clear understanding of who owns the copyright, there will always be a dispute as to who owns the copyright. One of the things you can do is you can utilize the National Association of Realtors has a number of contracts that you can use. You can access those in the MLS. You can provide those to your photographers to ensure that the copyright is going to reside with the proper author for the listing. So I would highly encourage you to utilize those contracts. Make sure if you're not utilizing those contracts that you have something in place with the photographers that you utilize in your market to take the photos for your listing. Okay, artificial intelligence. I'm just going to talk about it briefly to kind of close this, and that is AI is kind of all the rage. You hear about it with Chat GPT. Google has its new Bard product, and basically what AI is it's identifying and replicating patterns of data. So millions of photos, trillions of photos, millions of lines of data that enter into a database are scanned, looked at, and read for patterns. Over time, and with computer processing speed, AI has become smarter, more efficient, and easier to generate what we would refer to as accurate outcomes. In the initial stages of AI, you had a lot of what I would call bad data, a lot of bad interpretation, and just really not the best product that AI could produce. However, with the technology getting cheaper, databases getting more expansive, technology being cheaper and more efficient, and processors getting faster, AI can be generated quickly. It can also be produced quickly, and it can be generated within seconds using some of these new products. There are currently 2 interesting cases that are out there. One of them is called Getty Images versus Stability AI. And that case revolves around the input stage, sort of the ingestion of the copyright images to train data. And think about it this way. The AI tool is taking millions and millions of paintings, photos, pictures that are uploaded to the internet, and then basically allowing a user to type in what they're looking for the image, and it will create the image utilizing all of those millions of scanned and digested images that are out there on the internet. Getty Images obviously is a huge photography company that copyrights images and ensures that the copyright owners receive licensing fees for the use of their data. They have sued Stability AI to say that all of those generated images are not truly unique works of art. They are just copies of the Getty Images photos. And everyone is watching this case to find out what truly will be possibly the future of image-generated AI. The other case deals with an author named Chris Castanova. And Chris Castanova basically created a comic book and tried to register it with the Copyright Office for copyright protection. And what Chris did was she created the images utilizing AI for the comic book. And she submitted to the Copyright Office. They did not know that it was AI. However, they learned from her social media, from posts, that she had utilized AI to generate the images. And when they were looking at whether to issue the copyright for the comic book, the Copyright Office said, she is the author of the selection, coordination, and arrangement of the work's written and visual elements. However, she's not the unique author of the art that was used. And so what they did was they allowed for some copyright, but they didn't allow for full copyright. And this case is really important because this is the future of whether AI-generated text, whether AI-generated images will be seen by the Copyright Office as being worthy of being granted a copyright. This would apply to things like your agent remarks. Can generated text for an agent remark be copyrightable? Could a picture, an interpretive picture of a property, could that be copywritten with the Copyright Office? The answer right now is a little unknown, and the Copyright Office has to start analyzing data and technology, which is moving a lot faster than people can really keep up with. So it's I would say the thing to watch in the future is really AI in real estate. What does it look like? How can it be copywritten? How is there protection available? There's just lots of unknowns. And so I'm going to leave you with this today. If you're dealing with photos in the internet and you want to use a photo from a prior listing, you can't do it. You don't own the copyright. However, if you get permission, if you get a license to use that photo from the author, you can use it. So get permission if you're looking to use something that you didn't create. Also, if it seems wrong on its face, it's probably wrong, right? So don't go and take a right click on an internet page and try to download an image and then save it into your listing. If you didn't create that image, it's not your image. Without permission, you can't use it. And the last time, take the time to create your own works of authorship. Take your photos, take good photos, create your own descriptions, do the things that you need to do to protect your copyright on your listings. Those are your listings. They're the best representation of you for your sellers, and you want to make sure that it is unique and something that can be put into what we call the MLS compilation as a unique work of authorship that the MLS can then copyright as a database. So with that, that's your copyright primer for this sort of legal session here for the Utah Central Association of Realtors. Thank you for having me. Hope you learned a little bit about copyright. And if you ever have questions, don't hesitate to send me an email or give me a call. Thank you.